Hello, this is Allison from Prisoners' Rights Clinic. I'm here today interviewing our co-founder and director of litigation and legal education, Askari Lumumba, about a civil rights action he is involved in that is being orally argued this upcoming Friday in the United States Fourth Circuit Court of Appeals. So my first question for you this afternoon, Askari, is I noticed that the case is captioned LUMUMBA versus Kiser. Who is Kiser and what type of case is this?
Well, thank you for taking the time to do this with me, Allison. Jeffrey Kiser was the warden of Red Onion State Prison when I was sent there arbitrarily as an act of retaliation for what the state described as illegal group activity or attempting to start an illicit group demonstration. But essentially, what was being criminalized is my speech, because at the time they thought I had a lot of influence. So the case, LUMUMBA versus Kiser, is me against Jeffrey Kiser, because that is the prison I was housed at the time, Red Onion, when I initiated this case.
Okay. So we understand Kiser was the warden at Red Onion at the time. And why did you decide to file a habeas corpus?
Yeah, so when I went before the institutional disciplinary hearing officer and was found guilty arbitrarily, she decided as a penalty to take 6 months of my earned good time. And under prisoners' rights law, particularly the Prison Litigation Reform Act, prisoners are not allowed to initiate 1983s where the impact of the duration of their confinement is affected. So I ended up having to file a habeas corpus, and I have to get some sort of relief under habeas corpus before I will be able to go back and try to get some sort of damages under 1983.
Okay, so it sounds like another barrier due to the Prison Litigation Act.
One of many.
Right. So what court are you in now, and how did you get there?
Well, I'm currently litigating. Me and my legal team, I was appointed an attorney by the United States Court of Appeals for the Fourth Circuit, which they're headquartered in Richmond. I got there because I initiated, well, first of all, I appealed administratively through DOC and got no relief, and I initiated a state habeas corpus, which I was required to do by law, which I didn't get any relief, and then I initiated a habeas corpus in the district court, United States Western District Court, the Roanoke Division, where I didn't get relief, but the judge in the case, Norman K. Moon, granted me what's known as a certificate of appealability. And essentially what that is the court saying, while we are dismissing your case, we acknowledge that the issue is novel and that there are other jurists or judges who may disagree with us. And so because of this, we're going to allow you to appeal to the Fourth Circuit to get more clarity on the issue. So it's just essentially them saying, yeah, we're ruling this way, but we acknowledge we could be wrong. And so when I went to the Fourth Circuit thought my arguments were compelling, gave me an attorney, and this is where we are.
Oh, that's peace. So what exactly happened to give you the legal grounds for this legal action?
Well, I was at Sussex one state prison, and the prison was horrid. I had just been transferred from Sussex to state prison for similar acts, for a similar arbitrary charge, spurious charge, where they were saying that I was trying to organize guys under the banner of the Sussex Human Rights Committee. I was emergency transferred in the middle of the day, put in solitary confinement at Sussex 1. After public outrage and much political action on the outside by my support team, they ended up letting me out at Sussex 1. I was on the yard for a couple of weeks, and I began to talk to guys about the horrid conditions, and I was talking to people in society, most importantly through JPay and on the phone, about the horrid conditions. The state got nervous, so they criminalized my speech. They made up a bunch of accusations that was, they framed me and said that I was trying to organize a group demonstration without any evidence on the ground. Emergency transferred me. Well, first they put me in solitary confinement, and around 6 o'clock at night, that next morning around 8 a.m., I was being shipped to Red Onion 9 hours away, which means they was already planning this because Red Onion officials had picked me up. I get sent to Red Onion. I was placed in a solitary confinement, 22-man solitary confinement unit, by myself. Nobody else was in this unit. I was in this entire unit by myself, where I understand for 3 months. For the first 2 months, I didn't have my property or anything, so I was just sitting in a room. And they put me in a room. They put me in a mental health cell, where I couldn't flush my toilet. They had to flush my toilet from the outside of the cell. My vents were covered up with metal plates. So it was a clear act of retaliation and punishment for my speech and my organizing activities. Basically, GOC was getting tired of it. And so when I ended up going to my hearing, they found me guilty, arbitrarily didn't want to hand me my evidence, and so here we are.
Okay, thank you for sharing that. That sounds awful. Now, when you speak about the hearing, why do you believe the disciplinary hearing officer engaged in such flagrant misconduct?
Because there's no, and that's a great question, and that's because there's no accountability. And so in the administrative process in Virginia Department of Corrections is one which, you know, the overseers of the process are very much a part of the process. So the same people who are responsible for overseeing her conduct were basically the ones, you know, retaliating against me in the first place. So she was serving a particular function, which was to carry out her duty to retaliate against me, bury me, put me in long-term segregation, and make sure that I'm essentially neutralized. But because of public support and my team out there, they had to release me from my solitary confinement early, and because of my own unwillingness to comply and be complicit by not standing up, you know, here we are. We still fighting this case, and we still gonna get some justice.
Yeah, thank you for that, because the hearing officers are supposed to be a neutral party, but it sounds in this case they were not. Why is your case important for prisoners' rights as a whole?
Well, you know, just from a legal perspective, the issue I'm litigating involves the First Amendment. It's going to talk about the scope of our outgoing mail and outgoing communications in general, whether it be phone calls, JPay emails, or our correspondence or video visitations, or even with people in visiting room. It's going to talk essentially about what, you know, what our rights are with that, and whether or not it's going to be protected by a case called Turner versus Safely, or whether the scope is going to be determined by a case called Pecuna versus Martinez, which is a much more stricter and narrower standard. If it's protected by Pecuna versus Martinez, then that would expand the scope of prisoners' rights in Virginia, particularly with outgoing court communication. It would be something that would affect the entire prison population. So this is a big case. It's a big case. It's a First Amendment case. It's a free speech case for prisoners.
Okay, does sound like a big case. Thank you for taking this on. Do you have anything you'd like to say to the public before we close today?
Well, I would like to say, first of all, prisoners' rights are human rights, which is our slogan at the Prisoners' Rights Clinic. Prisoners' rights are human rights. And I think we have to stop looking at these things in a narrow way, in the same way that the people are struggling for the college students are struggling for relief in Gaza, in the same way that immigration lawyers are out there fighting to help ensure that people who are coming over here seeking asylum and getting relief from horrid conditions through the legal system. It's the same thing we're doing. It's the same thing we're doing in prison. It's all the same system that's oppressing us, and we're all trying to get the same relief. We're just in different positions. And so it's a human rights issue. First Amendment rights are human rights issues. And so we have to see it from that perspective, and we all have a right to exercise our voice, even especially more so in prison, because it's such a clandestine, secret place, and so transparency is important, not just for us, for our own safety, but for the public. You know, if we are going to be espousing so-called democratic values, and so I would just like to close out by saying thank you everybody for listening. Please follow the case.
Okay, thank you, Ascari. As always, we appreciate your information and perspective. This is Allison Chafin, Prisoners' Rights Clinic, thanking you all for listening. We will be streaming this case live on our Facebook this Friday morning, May 10th, starting at 8:30 a.m. We hope everyone tunes in. Until next time, peace.